combination, we have a set rule that if a combination, if a merger deal or an acquisition has the preliminary criteria for screening it is in terms of market concentration. Then they go for further analysis. So on the very first hand, they go for market concentration and they have a set criteria. And prior to that, not all the cases come, not all the combination cases comes under the scanner of CCI. So my question is like, and they have a particular asset-based slab according to which if a company or the merger or an acquisition bypasses that threshold limit, then only it comes under the scanner. So my question is like, what it's a set rule. So, but it as the literature is growing and as studies are coming up, it's seen that it varies from sector to sector. The threshold limit shouldn't be same for each of the sector. Say suppose for an agriculture sector, if a company is having a combination in an IT sector, where two companies are having a combination, the threshold limit, it might be that agriculture sector won't be coming into the scanner, but it is affecting the market. So people are telling that we should rather go for standard. Like the cases should vary. The judgment should vary from case to case. So what is your take on that? As the cases are coming up, so rules are. They are telling that rules are not better. Standards should be taken.
Yeah, thank you. That's a really interesting thing, and I would like to learn more about this. But it's really very interesting. You see, now assume you would have a judiciary in or public service, where you have lawyers and economists, taking the decisions, who are very high. They know everything about monopoly theory, oligopoly theory, market theory, and everything, and you can trust them. Then the best rule would simply be to say the merger has to be the merger cannot take place, is not approved, the merger cannot be approved if it significantly increases market power. That would be standard based, right? But that is the conditions under which this is the case are very different. Now assume you have an oligopolistic market where you have only two companies, each 50%. Or you have three companies, each has 33%, and two would now merge of them. So you have one company having 66%, one company having 1/3. Then you could still say we don't care if the conditions for a Bertrand oligopoly are fulfilled. That is, if these companies can in no time increase their production capacity. Then there is no difference between having an oligopoly, a monopoly. Oligopoly, monopoly. If market, if there is no barrier to entry into the market, and in an oligopoly, if there is, if production capacities are very flexible, like for instance, it is the case in the medical sector, producing pills, for instance. There, a high market share is much less of a problem for the consumers than in, let's say, car manufacturing industry, where you have fixed capacities and you have all the problems of the monopoly, Stackelberg monopoly, and so on, So I think if that is not the case, then it is perhaps better to say, well, we assemble our best economists at the central level, and they should write more precise rules and tell the judges what they should do. So, but it is difficult to answer that question generally. But from sector to sector, you might have very different threshold values from where you can say this is now really a problem for a market monopolist. But you cannot say simply, 30% or 40% is the threshold. That depends very much on the model which you can apply to a particular industry.
When we speak about rules and standards, we know that standards are more prone to corruption and because the people will be taking decisions there. So in that case, what kind of actions will you take, or what kind of rules you are going to set for these to avoid corruption-based decisions?
Yeah, well, first of all, this is right, because if you have, now assume you have a cartel law, take your example that of your colleague over there, and you have a merger, and the law would say, well, the merger cannot be approved if it leads to a significant market power. Then if you have corrupt civil servants or judges, they can always, make arguments and so on that this does not lead to a significant market power, and nobody really can see through it. So if you cannot trust these people, then it is better to have a clear-cut rule, let's say 30% or something. Because then the judges cannot be easily bribed. Because you can say, well, what the hell are you doing here? That is 40%, and you should not allow the cartel or the merger if it is more than 30%. So it is easy to observe when a civil servant or a judge has violated the law, right? So that is just the same as if we had a rule that car drivers should drive carefully, or if you have a rule that car drivers should not drive more than 50 kilometers per hour. That the latter can easily be observed, the first not. Of course, that does not curb corruption. It is only a reaction of the legal system to the possibility of corruption. To curb corruption is a totally different matter. But, in this book, Solomon's Knot, with Wakuta, we have also a chapter on corruption. We discussed this very carefully, and we had, the main idea, the basic idea, how to curb corruption, which we developed in that book, is the following. Corruption is always a kind of contract between a briber and the bribee. The briber gives money and gets something in return. So they must trust each other. But it is, even in the most corrupt countries, this is a contract which cannot be enforced. Now, for instance, if let's say somebody bribes a public official to get a government procurement contract, right, and gives him so and so many million rupees, and then expects that he can make the project that he can. But then the government official does not comply, so he gives it to somebody else, and you have paid 10 million rupees for it, let's say. Then you cannot go to court and say, we have a contract, That is not possible, even in the most corrupt country. So bribery is always based on a non-enforceable contract. Now, we have the theory of non-enforceable contracts, which says that if contracts are non-enforceable, if the legal system does not work, everything depends on the trust, on the conditions under which briber and bribery, they trust each other. And therefore, you can, there is a mirror symmetry between building up trust relations for contracts and destroying trust relations in bribery. So what the basic idea among destroying trust, that the basic idea is that you should ask or look for instruments which destroy the trust between the bribee and the briber. And for instance, Kaushik Basu, the economist who is now the chief economist of the World Bank, he has made a proposal along these lines. And he said, well, for instance, he said, you have in India, for instance, you have to pay a bribe for almost everything, whether you want a birth certificate or a death certificate or a passport or whatever, you pay the fee and you make some bakshish. And is that right? Is that correct? Yeah, okay. And he asked himself, how can we change this? Because you have many countries which are very corrupt, like Turkey or China, but this kind of petty corruption does not apply in Turkey or in China. Kaushik Basu says, well, we can simply destroy the trust relation. So, for instance, you could say that if, to bribe a government official is a crime in India, everywhere is a crime. And he says, why should that be a crime? You could say, well, I bribe the government official and then I get my passport and then I go to some agency and say, well, for this I have paid a bribe, let's say of 500 rupees. I want this money back. And you get the money back and the person is punished. You see, and therefore the game theoretic argument behind this is that if you bribe a person but get the money back later on, if you report the bribe, then of course the other side knows this, and he knows that if you pay him the bribe, later on there is a large probability that it is still reported. Because you could even say, well, you bribe, if you pay a bribe of 500 rupees, you can make a law or a rule to pay back 1,000 rupees, twice the bribe. You get twice the bribe back. Then you have a big incentive to report, and then the other side also knows this and will not accept the bribe in the first place. So you have a mechanism which destroys the trust relation between the briber and the bribee. And that is the way how the general starting point of how one can fight corruption by destroying trust relations. Yes.
So, but in this particular example, isn't there an underlying assumption that you can prove that I bribe? I mean, how do I prove that I...
From an evidentiary point of view, it will be very difficult.
No, you go to the railway station, you pay to the Rajdhani TT that, okay, give me the ticket at this moment, right? You carry the ticket and then you prove that, see, I came here, my name was not there and still I got the ticket. This happens all the time. But only that you don't report it, because there is a social dimension in India. Say there's a poor lady who wants to travel. Something like this in India, Mm. So, if you want to adopt a baby, for example, uh, you bribe the charity that, okay, you show me only the boys who come, okay? Not the girls, only the boys, because there is a rule by charity that the first baby that they pick, it can be a boy or a girl, right? Now, this is the type of thing that you do in India. So then when someone hears it, there is a social angle attached to it.
But sir, I think those would be some of them. Like the example sir gave of passport. I mean, once I've got the passport, how do I prove that I got the passport? Because I bribed, or is it because of the proper channel?
I think India, we've got this Tatkal and all this online thing which has been done. So all those people who sit just outside the Delhi office, passport office, all those sitting people, now you can avoid them, and then you can get your things. Say tomorrow if you have to travel.
That is fine. So, but like in the driving license example, earlier they had a written exam for the learner's license. Now they have made it online to improve efficiency, I would say. But then what now they do is that the person would be there inside the computer room and would tell you answers so that at least 6 out of 10 are correct. So earlier they would mark it correct. Now they sit on your head and tell you the answers.
And remember though that those people who would stand there, and then you have to drive like an 8. You have to drive like an 8, and this guy would say, okay, done, and you're not even driving, and they will say, okay, yes, because the money has reached.
So precisely, that's what my point is, that you might be able to, you might be able to prove in some certain cases, but in most it's invisible.
I think the other way can come true, because we have to break the trust. So whether the one who gave the bribe has the power to report, or the one who takes the bribe has the power to report. So in either case, we can seem like in some cases the one who bribes has the power to reveal it, or in other cases the one who has taken the bribe has power that he has given me the bribe. So if a combination of this can happen, then I think there is a more plausible solution to it, because we have to just break the trust, and it can happen only when one has the potential loss, not both.
Yes. Well, I don't deny these problems which you said. I think they are very real, and so I do not want to push this too far. That was only an example. What I mean is this: that the starting point when you try to fight corruption, the starting point is always that you make yourself clear that bribery is a contract first. There's a quid and a pro quo. So there's a contract. There are two parties, and each party has to contribute to the contract first. Second, it is a contract which is not enforceable. So if one party pays and the other party does not perform, you cannot, unlike for a normal contract, go to court and say, well, here government enforce the contract. It is a non-enforceable contract. Third, the theory of non-enforceable contract is a theory of trust. So if contracts are not enforceable, then you have to build up trust relations between the contracting parties. And there is a whole bunch of literature which shows us how trust relations can be established between parties. And then the fourth is that when it comes to bribery, you do not want to build up trust, but you want to destroy trust. So the destruction of trust is the starting point of every feasible strategy of curbing corruption. That is my point. And then, of course, when you come down to the practical problems, you have lots of practical problems, but I'm sure that this proposal by Kaushik Basu, for instance, which is in this line of thinking, has its limits, certainly, but it has also its great merits. And but however, I think it was not accepted in. There was a discussion here, but it was not really.
So he came up with a paper.
Yeah,
He was here
yeah.
as a chief economic advisor.
Yeah.
Minister of Finance, he came up with a paper with NIPFP on the same part, and he divided the bribery in two parts: harassment bribery and non-harassment bribery. So he said that this system can be applicable only when there is a non-harassment bribery, not the harassment bribery. Like the passport case or the driving case, these are called as a non-harassment bribery. Like we want to have a birth certificate, just you go and pay the money, fees and other money, and you get and then you say that I have given the bribe. And the paper name is why for a class of bribes the act of giving a bribe should be treated as legal. This is the paper he wrote it.
Interesting one. One incident in how bribery happened in a higher echelon, and judiciary is no exception to that. A case which I have witnessed, trust deficient and all that. There was a lawyer who educated from King's College, Oxford University. He is the son of a judge, having very good practice at Madhya Pradesh High Court. He appeared in a matter of some mining lease matter. The judge gave the stay order, and when that lawyer went to this chamber, something happened with that client, some altercation and sort of a thing. The client goes to the Chief Justice saying that that lawyer has taken 25 lakh to obtain the stay. The entire judiciary in an inner circle was shocked. Judge has taken 25 lakh and granted the stay. And since he is a son of a judge also, so there may be remote possibility. In inner circle, the Chief Justice has investigated the matter on a personal level. Thereafter, in open court, we called that lawyer, and he simply said, Mr. Counsel returned that 25 lakh rupees. And in the chamber, the judge was also called. This is a case of High Court. The High Court judge was called, the lawyer was called. Lawyer was instructed to refund that 25 lakh. Lawyer was denying that I have not taken a 25 lakh rupees. Then judge went to the court and vacated the stay order. And money was refunded. So, according to this theoretization, merely by reporting the fact to the Chief Justice, he got his stay vacated and he lost the case. Eventually that client suffered. And the lawyer is still practicing in the court, and that matter went in a silence, it was silence. So, two things is there. I don't know, I'm definitely going to tell these people that what you have written on corruption. Law and economics as a discipline. This is a economic analysis of law. And there must be a legal analysis of economics also. So some sort of a jewel text has to be there out of this economics. Because in a higher echelon, unless and until you are not going to understand the economy of this all bribing, taking money, managing the courts, managing the judges, it's impossible. The jurisprudence we have today, it cannot trap that area. You don't have offshoot of this. So it is good that somebody is reporting and somebody is not reporting. But even after reporting, what will be the course of action? That is a suspicious one. Even the higher echelon. That lawyer is working. Tomorrow he may be judge, he may not be judge. That is a pathetic situation. Very. Since this is a conference, I can say so, but otherwise it would have been a contempt of court.
Fully economic. We would have believed that economics is like natural science, but unfortunately, Whether you bring lot of statistics, maths, it is yeah.
Since you're a
It is
you're a torchbearer of this
social science.
law and
It's not
economics.
C plus O2 CO2 like the
From Indian perspective, what I personally feel, being a lawyer, okay, economic analysis of law, it is important for economists, because in economics policy, some where the law comes in. But proper administration of justice, there must be some jural text which came from the wisdom of economics. In India, which is lacking, like in a cartel case, I argued that matter of cartel. This young girl, oligopoly, or I never knew that concept that time, and it was misfired. And today I feel it's a bad judgment. It's a bad judgment. Cartel have that. Cartel is not always a taboo. But what we consider cartel in a judicial way, that is a reported judgment of B.S.N. Joshi versus State of Maharashtra. Any speck of cartel is bad, and we have not considered the monopoly and oligopoly. So without considering this aspect, these judgments are misfired, and this is creating a great trouble to both of the nation. I hope you subscribe or you add just on to it.
Yeah, well, you know, as I told you, when it comes to cartels, we have in my country, our tradition of very far-reaching wrong Supreme Court decisions. You know, as I told you, in the late 19th century, the Supreme Court endorsed cartels, not understanding their distortive effects. But after the Second World War, we had a very strong economic group in Germany of economists and also lawyers. That was law and economics just related to competition law, and they were very influential and very successful in influencing the law and the competition law, and therefore Germany, I think, was the first country in Europe which had a very sophisticated anti-cartel law. So it all depends on whether you have theories which are really workable, which are good, which explains the world, well, which are adaptable to the law, and which then can influence lawmaking. And this was the case in Germany. So what I'm pleading for is that in general you should have more cooperation between lawyers and economists, or lawyers and social scientists in general. I think that the purely dogmatic and doctrinal work in law is a thing of the past. It has not much future. And if you look at what the law schools in the United States, you know, the Ivy law schools, what they do just that. They are, moving away from doctrinal work, and they are more looking on the consequences of the law, the consequences of legal norms, and that is where I think the legal scholarship of the future will be. I'll give you just one example which illustrates this point. Perhaps you have heard of the University of Princeton University. Princeton, the idea of Princeton University was to have theoretical scholarship on the highest possible level. So these professors there at Princeton University, they have no teaching obligations, except some doctoral students are there, but it's not a teaching university, it's just for research. and for theoretical research. Now, for that reason, because they said we want theoretical research, they had mathematics, they had physics, they had economics, but they had no business administration, and they had no law, because they said law, that is not theoretical, there is no theoretical work is not possible in law. And therefore they had no legal faculty. Now, I was at Princeton University for a couple of days in 2013, and I had the privilege to talk with the president, Cohen of Princeton University. We talked about law and economics, and he said, well, we are just in the process of establishing a law faculty here. Because law is changing. It is not just, a collection of practical things, a collection of practice, best practice or so. It is becoming a legal, it's becoming theoretical, it is becoming by the way of interdisciplinary research is becoming a real discipline with, which explains something and which is not just a sphere for practitioners. And then they established a group of lawyers, and you can look it up in the internet. They have now published already 50 or 56, 57 working papers since then, Princeton University Press, and all of them are of this interdisciplinary kind. There's no purely doctrinal paper of them. That is the way the law, the discipline of law works, and that is the way how law becomes a powerful discipline, academic discipline, which has also then the scope to influence legal practice and parliaments and decision makers, just as economics.
So I actually wanted to modify the question that I previously asked. So sir, I said no rights. So
Pardon?
I wanted to modify the question that I already asked. So sir, I said a situation when there were no rights granted to the farmer.
Yes.
It's actually the situation that I want to ask about is a place where the farmer has been granted injunctive rights. And that is when the rancher decides to pay the farmer 150 rupees. Okay, so now the net becomes with the farmer for a situation when the farmer will not decide to fence. It becomes 50 rupees. Because if I don't fence, then I always suffer a loss of 100 rupees. And I have been given 150 rupees. So the net becomes 50 rupees. If we compare that to the other situation, when I decide to fence and I am the farmer, then the 150 is being contributed by the rancher and a 50 is being contributed by me because the fence costs 200. However, the net again becomes 50 because the loss that is now being saved is 100, but I have put in my 50. So what I'm trying to say is, for the farmer, the situation in both these cases is the same, whether I decide to fence or not, when I have the right of injunction against the rancher and I'm being paid 150 rupees by the rancher. So I want to know that how is it not changing, or how is this not posting allegation, in the sense that this right of injunction changes the incentive for the farmer. Like, I can decide to fence and I can decide not to fence. So the efficient solution was not to fence initially, which should have remained with zero transaction costs and the injunctive right. But now, though it is not drastically changed, but I have an option of fencing if a right of injunction and 150 rupees are being given to me by the rancher.
Yes, but that would only change the wealth, the relative wealth of the farmer and the rancher, but not the allocation of resources.
Okay.
And you know, when we, what is your background? You are an economist or lawyer?
So I'm a law student.
A law student, yes. Well, you see, you are totally right in saying that it makes a big difference whether we have an injunction or no right at all, right? Because in one case, the farmer, if he has no right at all, gets nothing, and in the other he gets 150, right? And that makes a difference. That Coase would not deny, but what Coase would say, that is not only Coase, that's what almost all economists say. You know, this is purely redistributional. That is distribution. We are interested in efficiency. We want to look at whether the fence is built or whether the fence is not built, whether resources are wasted in the economy or whether they are used efficiently. And therefore, we do not look too much on the distributional effects of these things. They might be important, of course, but when we concentrate, not that we say this is totally unimportant, but we concentrate only on this question: will the fence be built or will the fence not be built? That is the obsession of the economists, you know, when they look at efficiency, right?
This WTO, at least 20 years back, because it was formed in 1995, the bureaucracy was such that there were 80% lawyers there. So what came out was like the constitution was subject to different interpretations and so on. But what's happening now is that with these mega blocks coming in, like this TPP, Trans-Pacific Partnership, in US and Pacific Rim countries, and RCEP, that is ASEAN plus 6. You see these WTO plus issues. Now they are saying WTO multiplied issues coming. One example being state-owned enterprises. Now they are saying that it has to operate like a commercial enterprise. Now in India, problem is, say if you want to build a railway track in a mountainous region in Jammu Kashmir for security reasons. Now to justify public procurement or to justify that there are security concerns, it gives a break on fulfilling your objectives here. So that's the pressure which is coming in, that SOEs have to operate like a commercial enterprise and things like, and various other TRIPS is an old problem in India. For example, how do we define new chemical entities? Because of this insecurity that we had with the governments in the 80s, especially Indira Gandhi and present incumbent to the president, we have defined new chemical entities in such a way that we have had a very open definition. What is a prior art? It shouldn't be obvious to someone who is skilled in that area. It should have industrial application. For that second part, we have said that anything which is of economic significance or anything which is technologically superior will be not obvious to a person who is skilled in that art. Now that means in this world everything is of economic significance. So Professor Schleifer, you won't believe, for 300 new molecules that were formed from 95 to 2005, we have received around 9,000 applications for new NCEs. So we had written in Journal of World Intellectual Property Right that time that lot of cases would come in, and that's happening. Novartis or all these organizations, they are trying to prove that whatever we have done little bit is a new chemical entity, while NGOs and common people have been saying that it's the accessibility which is important. So that tussle that you say, producer versus consumer, somewhere that trade-off is not an easy answer. It's a difficult one. But then lawyers are gaining out of it. I'm sorry, the profession is that is the things.
Sir, the nature of reform, you said, should not be divisive. I mean, the post-reform society should not be divisive. If the pre-reform, like the society is already the existing practices or the existing situation is already divisive. Let us say the case of affirmative action that we take or reservations in India. The post-reform, after bringing out reservations, the society got divided very. There's a big chasm between the privileged and unprivileged according to the reform. So, if the reform, the nature of reform is, let us say, right, if the unprivileged groups or historical wrong is being set right, but if it is inevitably going to result into a divisive situation, is there any pointer as to how to go about these kind of situations?
Well, yes, I think this is a very deep question, and of course, I mean, there are certain situations in which you cannot simply say, well, a reform should not be divisive. I give you an example. I give you an historical example for that. Perhaps that answers your question. When the United States were founded, we have in Europe, we have anti-Americanism. It exists everywhere, but especially in Europe. And I can tell you exactly when anti-Americanism started to exist. It was when the United States filed their Declaration of Independence. And that was for the following reason. Amartya Sen has written about this in his book, The Idea of Justice. The leftists in Europe at the time of the American Revolution, the American War of Independence against the British, they said this Declaration of Independence is a foul compromise between men of the Enlightenment and slaveholders, because when they established the United States of America, they agreed, they had the highest principle of freedom and independence and everything, but they also accepted slavery in the southern states. So it was in a way also cynical, because Britain had just abolished slavery a couple of years before, and in the Congress of Vienna, slavery was abolished for the whole of Europe. But the USA had remained a slave state until the Civil War. And only in the Civil War, Abraham Lincoln corrected this birth sin of the United States and abolished slavery. And that cost the lives of 600,000 American soldiers out of a population of then 25 million. So they paid a huge price for that in terms of blood to abolish slavery. So you can say this was the right thing. What Lincoln did was the right thing to. So you cannot always say, we have to Pareto improving reforms and so on. President Lincoln was not that type. But now take the example of Brazil, also a slave state. So in Brazil, they abolished slavery without one shot fired. A little later, 10 years, it took. So the first thing they did not abolish slavery, but they abolished the trade. They abolished import of slaves. That was the first. and it was also badly enforced first. But it's still, there was they stopped with importing slaves. That was the first steps. Then a couple of years later, they said, well, we can free from slavery the elderly, those who do not work, let's say over in my age. So all the elderly people were freed from slavery. And then the next step, and so that the slaveholders, they also said, well, okay, the elderly, no problem, and so on. So the interests of the slaveholders were taken into account. Then they said, well, in the future we don't want to have slavery. You can keep your slaves, but every person born in Brazil is a free man, is a free person. So there is no slavery anymore. Still there were slaves there. And then a couple of years later, so in a sequence of events, then they freed all the slaves. So now I ask you, I don't have the answer myself, but what is the better way to get rid of the slavery? As Abraham Lincoln did it, or as the Brazilians did it?
Brazilians. Considering the bloodshed, I would say Brazilian matter was the Brazilian case was better, but
so the Brazilian, it was then still a Portuguese colony at the time when that happened, and there was a princess, Portuguese Princess Isabel, who was, pivotal in this, and she managed this over a period of 25-30 years, and at the end of that, Brazil was a country without slaves and without one shot fired. You see, that is the difference between a reform which which says this is the right thing and we have to do it, cost it whatever the costs are, and the other, we have to have these reforms. There are losers. The losers are entrenched. They fight like hell for their interests. We have to take that into account to some extent, but never lose what we want to have. And at the end of the day, it worked in Brazil. So I must say, I personally, even though I do not want to take sides, I have more sympathy with the Brazilian model to abolish slavery than rather with the Lincoln model to abolish the slavery. See what I'm...
So, coming to the example of coast theorem.
Yes.
So, what if the rancher doesn't have so much of money to pay to the farmer? Like we were presuming that the rancher will pay 150 to the farmer, but what if the rancher is so poor that he cannot pay to the farmer?
Send him to imprisonment.
He will be indifferent between shutting down his ranch.
Imprisonment.
So in that case, he will be indifferent between shutting down his ranch or paying to the farmer.
Let me see. Now, you say the farmer is if the farmer is so poor that he cannot pay this, the rancher is so poor. You mean the rancher is so poor that he cannot pay this? Well, yeah. Then now assume that you have low transaction cost, no transaction cost. Then this also means that you have a perfect capital market, a perfect financial market. Then the rancher can take up a credit. The rancher can take a credit now and pay from the credit. And he makes profit from the ranch, But now assume you have all these things at place. You have non-performing financial markets. You have poor people, poverty, and so on. Then, of course, the Coase theorem does not apply. It's as simple as that. And then you have to have a rule. I will explain this tomorrow. You have to have a rule which, from the very beginning, gives incentives to reach the efficient solution.
Yes.
Well, of course, you could sometimes say, well, if there is assume there is a group which is so poor that you cannot do something, they cannot pay anything, then you have to give up the efficiency criterion altogether. You see, that, however, that is a problem which is, of course, more important in India than in, let's say, in a Western country where we don't have absolute poverty, and where. But that is not the main point. The main point is that in Western countries, you have that it doesn't happen that somebody is so poor that he cannot maintain himself, because everybody is entitled to a social welfare payment, and therefore the more you have such social welfare payments, the more economic policy can concentrate on efficiency matters. So if you don't have social welfare, then you have always to look at whether something is efficient, but it might be efficient, but then it has huge consequences on poverty groups. Then you cannot do it for this reason, and therefore it has always been my conviction that social welfare state is a necessary corollary to a market economy, to globalization and so on, because you have to look for efficiency, you have all kinds of external shocks and so on, which are buffered by this. But if you don't have this, then you must always trade off economic policy considerations of efficiency and growth and wealth, increasing wealth, with social welfare payments. And that is not a good combination, in my view. So, I mean, it is not it is no way an accidental that the welfare state started to develop in Europe at a time when the European nations entered into the area of world trade and globalization. It is an instrument to buffer against the hazards and risk of the market and globalization. And I personally think that a country which does not have this, then the whole market system is always under stress and under strain and is not accepted and will always be questioned and so on.
Good answer.
So, time is over.
Yes.
So we do not want to overstress you, overtax you. So we see tomorrow, and tomorrow we will. I will tomorrow start with this tragedy of the commons and the anti-commons, and then I think we go to contract law, right?
Tomorrow it is Professor Uday Rajan.
Tomorrow, right? Yes.
The
The
day
day
after
after tomorrow. Yes. Okay. So you should read this on contracts and on also what you have there on the tragedy of the anti-commons. That is especially this Calabresi, this thing of Calabresi about property versus liability rule. That is very important to understand the commons problem and the anti-commons problem. That is our next topic. Okay, thank you.